Hello, everybody, and welcome to this month's Specifying Practice session and the first session of the new year. I do want to hand it over to David to get started with today and let him introduce our guest speaker. So, David, over to you.
All right. Thank you very much, Matt. This is Dave Stutzman coming to you from snowy southern New Jersey. We're looking at probably about 10 inches of snow that we got overnight, so this is a real delight for me. The roads are empty. The office is empty. I'm the only one here. And today it's my pleasure to introduce Dr. Ujjval Vyas, who's a business associate of mine and is working with Conspectus. He's a past or former practicing construction attorney. He's also a professor, having taught architectural history. So he's intimately familiar with the industry, and he's a often presenter at some very high-level conferences. So we want to welcome him here today to share some of his information that he has on fiduciary duty. Ujjval?
Thanks, David, and thanks, Matt. I really appreciate it. This is, it's a privilege again to be talking to CSI. It's always interesting. It's a fascinating group of people dealing with a very, very important and I think pivotal piece of the construction puzzle. This is going to be as both Matt and David have indicated, in some ways, this is a relatively interesting and challenging and often very, very difficult topic for many people to wrestle with. I'm going to try in the next 30 to 40 minutes to give you the very, very broad outlines. But I do realize that there are a large number of folks, and I've been talking publicly about this topic only for about a year and a half, and I've been working on it for almost 4.5 to 5 years. So it's been a lot of peeling of the onion down to the first principles, and I think that's really the key attribute to take away from this talk, is that what I'm presenting here is based on fundamental first principles, both in law, and although I'm not going to go into the law and economics issues here in any great detail, that's also very, very thoroughly worked out, both in parts of the law and economics literature, but in other areas. For those who have an interest in pursuing that further, happy to give you more details as to what to reference. The key things that we're going to be talking about today and why this title, the title of this talk is called The Twilight of the Gods, is that up until this point, the idea of a licensed learned professional has been driven by a specific set of what are fundamentally erroneous propositions about the way in which arm's length transactions work in this area. And the erroneous part, especially once you get down to the first principles, you understand that it is clear that design professionals have a affirmative fiduciary duty to their principal, in this case client, which is based purely on the status of being a licensed learned professional. Now, this is going to be very challenging and interesting, and I'm sure there are many people on this call, whether they're architects or if they're involved in insurance or involved in engineering or other sort of arenas, who have been led to believe for a long, long time that the fiduciary duty is essentially a kind of post facto duty driven out of contract. This is not the case. And the confusion in the courts results from this misunderstanding, and I'll try to talk a little bit more about that, which is, see if I go to the next one here. Just we've done our introductions already. As David said, I have a very long background both in teaching the history of architecture. I taught the theory of architecture. I taught design studios in architecture and was a practicing construction attorney for a decade. And then I moved on to doing essentially consulting in the construction industry. And Alberti Group is driven primarily by making the construction industry and the built environment significantly more efficient to deliver and to understand the fundamental basis of a lot of that activity, both in terms of the underlying economics and in terms of a lot of the cultural and intellectual issues that are involved there. For me, this particular topic of the fiduciary duty is quite revelatory in its capacity to improve the industry significantly by making the industry significantly more efficient. In fact, I would argue very strongly, we don't have time to do it here, but this essentially replaces IPD in a much more coherent fashion, and will be proceeding in a cascade relatively soon. So, lots of people think maybe this is just an odd idea that Ujjval has, but in fact, we have put together for quite some time now, for probably the last 2 to 3 years, something called the Fiduciary Duty Initiative, where major players in the brokerage world, meaning construction, insurance, and surety brokerage, architects, owners' representatives, owners, and a number of other individuals involved in the A&E insurance markets have been talking for quite some time about this topic. And we are, frankly, going to be putting on some major sort of events this year, a full-day event in Detroit. This kind of thing requires much more even than a full day, and a full-day event in Chicago, and we're planning on a full-day event, if we can pull it off, for London later in the year or early next year, because what we're going to be talking about here applies to all common law jurisdictions. It would apply wherever common law is used. So what am I announcing here? In a sense, I've talked about this quite a bit. CSI presentations, I've done a few where people have freaked out, have attacked me in various ways, and other CSI and specifiers and architects have thought this was long overdue. So I expect pushback, and as many of you know, I'm used to that. That's partly what I do, and wearing the target on the front is something that I'm very comfortable with. So what we're really talking about is how we're going to change the profession for the better and take it from being 19th century gentlemen to 21st century licensed professionals. And this is both for architecture and engineering. It applies in both areas, but of course, architecture in a certain way prides itself on having a certain cultural privilege of demigods, which is often not the case for engineers. So this is going to be a difficult transition, but a transition that has to be made and will be made very, very quickly. And I reference the idea of a quick transition here, and we should remember that the quick transition took place in medicine. Many of you may know, although many of you may not as well, that the coming of an informed consent duty or a set of fiduciary duties for physicians did not fully arise until the late 70s and the early 80s. And once it became clear that physicians had such a fiduciary duty, in the same way that it is now clear that architects have such a fiduciary duty, it became very, very clear that all the parties in the industry had to make rapid changes to make sure that that fiduciary duty was met by both the practitioners and the way in which they were educated, and the underlying practice of that discipline had to be changed. And that's really what it means to be a 21st century licensed learned professional. You can no longer, and we'll talk a little bit more about this, is that the fundamental mistake that was made is to interpret the necessity for the transactions and the interactions and delivery of services as contractual engagements. In fact, contractual engagements are not the primary mechanism by which fiduciary duty is fulfilled, nor a licensed learned professional can practice. And we'll talk a little bit about that, and that's really the core of the proposition here. For some reason, my computer is being a little slow here. Okay, so what is this thing, and how do we want to talk about this? Fiduciary duty exists in relationships that are not at arm's length. Every relationship between a learned professional who is acting as an agent for a principal is not at arm's length. This is important to understand because when it is not at arm's length, it's clear that contracts are not the primary mechanism by which the engagement is understood. So, to continue, or where there are asymmetries of power, knowledge, or prestige, and the principal, in this case, if we're talking about the architect or the owner, architect or the engineer, it's going to be the owner. The principal lacks meaningful capacity for oversight to prevent opportunistic behavior of the agent. And at this moment, lots of people say, yeah, but I have lots of sophisticated clients. You know, those guys are owners. They got their own people. But that's not the same as having meaningful capacity for oversight to prevent opportunistic behavior of the agent. And always remember that whether you're an attorney who has a fiduciary duty, a physician who has a fiduciary duty, an accountant who has a fiduciary duty, that in fact, it is very common for all those transactions to be between extremely sophisticated parties. The sophistication of the party is not an indicator of the way in which the risk is to be managed once fiduciary duties are involved. So, the fiduciary duty is an affirmative duty. What does that mean? That means that you don't wait around to see if you get sued. This is not an after-the-fact problem. This is a before-the-fact problem. It's affirmative. It's an affirmative duty from the agent to the principal, and this is created via common law equity principles, contract, or what we're really interested in here, although we can talk about some of these other issues, is by a sovereign as a state-conferred status. Okay? That's what it means to be licensed. The sovereign gives you authority of some type or provides a status for you of a particular type. Okay.
So, Ujjval, in this case, you're talking about the architectural license or the engineering license that the state confers that essentially gives the architects and engineers the right to practice, and because of that, it puts them at a fiduciary duty.
Absolutely. The same way that you're licensed to be a physician, or you're licensed to be an attorney, or you're licensed to be an accountant. Note that this is very different than if you're a biochemist. You can be an extremely learned member of a profession, but you're not licensed to be a biochemist.
Okay, and to back up and just to make clear one point, in this case, the principal in the relationship architect or engineer to owner, the principal is the owner. The agent acting on behalf of the owner is the architect or the engineer.
Exactly right. Exactly right. So this is, I mean, in sort of legal or law and economics parlance or an agency law parlance, this is actually a principal agent problem. And many, many decades of work have gone into principal agent and agency problems. One of the things I want to stress is that although this seems very, very new to this particular audience, or an audience involving architects or engineers, people in the A&E insurance industry, in fact, this is an area of law that has been very, very carefully and sort of worked out in great detail. So the fact that it appears new to this particular arena doesn't mean that it's actually a new idea at all. It just means that frankly, it took somebody who was willing to spend enough years to peel back the layers of the onion to get to these first principles, to reacquire how this is to be done. So what is the fiduciary duty? How is it structured? A lot of this is already been worked out in many other areas, but the principal engages the agent, a licensed learned professional, provided a state-conferred monopoly for the provision of such services, to use his or her knowledge and judgment for the benefit of the owner before any benefit to him or herself. And this is the crucial attribute of a fiduciary duty. You are looking out for the benefit of the owner first. And there's a key secondary attribute. We don't get a chance to talk about this here, but what you're really doing is you're maintaining the decision-making integrity of the principal. If you're a physician, you're maintaining the decision-making integrity of the patient. You're not substituting your preferences for the patient's preferences. If you're an attorney, you're not substituting your preferences for the decision-making of your client. It's up to the client to decide in any fundamental material way what is to be done, not for the attorney or the physician to make that decision for those individuals. As a simple example, David, and for everybody else on the webinar, I often ask this in person. How many people want to return to a time when physicians did not have a fiduciary duty to their patients? Surprisingly, no one raises their hand. because the same members of the audience are often fighting tooth and nail to tell me that there certainly cannot be a fiduciary duty in the world of architecture and engineering. Same thing is true in law, except that the development of a fiduciary duty in law, ironically, already started in the 14th century. So, what this means is you have to protect the decision-making integrity of the principal, if you're the agent, and you deploy your knowledge and judgment for the benefit of the owner first. And the easiest example here is in the financial services industry that all of us sort of know just enough about to be dangerous, but this example suffices. You have the capacity to take your money, if you have such money to do it, to a broker, a money broker or a money managing broker, or to an advisor. And the difference is that when you take your, whatever, as I always say, Uncle Louie left you $9 million and you need that money to be taken care of. If you take that money to a broker, that broker's duties are not to you first. They're to the broker first, and his job is to make as much money as possible off of your $9 million that you place with him. If you're an advisor, that advisor has a fiduciary duty to you, and therefore his job is to take that $9 million and to protect your interests first before his interests.
Ujjval, we have a question from Kevin O'Byrne, and he's asking, is it being suggested that any licensed professional has a fiduciary duty simply because they have a state-mandated license? Does this mean a massage therapist has a fiduciary duty?
A massage therapist is not considered a licensed learned professional. There are many people. Occupational licensing is not the same thing. There's very, very few licensed learned professions. There is engineering, explicitly said so in cases that are brought before the Supreme Court. Clearly law, clearly medicine, physicians, and occasionally and accounting. Occasionally people try to talk about maybe veterinary medicine or other types of things, but it's also very clear that the license that is given to a learned profession is radically different, and I'm going to go later on here and define what this is for the benefit of others, as opposed to occupational licensing. Okay, and that's why this is an interesting problem. I get this question all the time. My hair braider requires a license, but nobody thinks that the hair braider has a fiduciary duty to me. Well, that's an occupational administrative license that the state extracts, usually for it's kind of tax almost. That's not what a licensed learned professional is. Okay, the reason that the state confers such a license on that group is because the state recognizes that the services are extremely important for the maintenance of fundamental parts of the economics and other pieces of the state, and is willing to give them this type of monopoly. All right, I'll cover that in just a second. And happy to provide greater and more detailed references on these things as well for those interested. So one of the things that's important to realize is, and I'll talk a little about this later if we have time, I know things are just slipping by quickly here, but most importantly, a fiduciary duty has nothing to do with a contractual duty or a tort duty. It is a completely separate, third, independent duty, which is owed to the principal and is an affirmative duty, and as such becomes the ruling duty, which is constitutive of the delivery of the services. This is often forgotten in things like, a lot of physicians don't know the details of this. A lot of lawyers may sometimes not know the details of this, or accountants. And that's because what transpires is that affirmative fiduciary duty becomes absolutely constitutive of the practice of that profession. And as a result of this, it often gets confused with a standard of care. And that's a more elaborate and sort of subtle point, but it is important to remember that there is a specific duty of loyalty and a duty of care which is associated explicitly with the fiduciary duty. And I just want to say one additional thing about this slide here, which is one of the most interesting parts about a fiduciary duty is you have to actually tell your principal when you don't know things. You don't have the luxury of trying to fake your principal out. If I'm a cardiologist, I don't have the luxury to say, well, you know, okay, I operate on the heart, very complex, I'm super skilled, I'm a highly dynamic demigod of medicine, I can go ahead and do this other type of surgery. Or I can go ahead and give psychiatric advice. The amazing thing, of course, is that the history of medicine is characterized by this kind of general knowledge in the 19th century. And there were many schools of general knowledge, and the battles were between styles of medicine. I learned my bloodletting at Cambridge, and therefore, or I learned my, phrenology in Paris, and therefore, fill in the blank, right? And then also, of course, it's obvious to anybody on this call, on this webinar, who is a lawyer or a physician, and certainly a CPA, conflicts of interest have to be revealed, and you have to be completely transparent. And that's one of the most important ways to understand what it means that it's an affirmative duty. You don't wait around to see whether your client will ever discover that you have a conflict of interest. You have a duty to, in fact, affirmatively say, I have a conflict of interest. And such a conflict of interest is not just in terms of a product. It can be in terms of, hey, I'm completely biased about this topic. I can't be objective. You have to tell your client this, all right?
And you had one point there, Ujjval, I just wanted to talk about, because you skipped over it a bit, that there also comes a duty to inform the client that you do not know, that you cannot help in a particular area because you do not have expertise in that area.
Yeah, absolutely right. I put it under the idea of when you're ignorant about something, you have to tell your client, but you're also right. You have to tell them. As I say often, if somebody comes up to me and says, hey, Ujjval, I understand you're an attorney. Now, I don't practice anymore, and as all of you know, nothing I'm saying constitutes legal advice. But if somebody were to come up to me at a cocktail party and say, hey, I know you're an attorney, can you help me with my bankruptcy? I'd say, absolutely not. I know nothing about bankruptcy. I might be able to help you find somebody, but I have to tell them right away that I can't do that. And that's a very interesting problem in architecture, right? Because architecture often moves forward, or the success of architecture is how you make assertions about the world, as opposed to demonstrate performance in the world, right? So let me just cover this. I know it looks like a very long thing, and I apologize for putting it in here. But I think it's important just so you have it there in front of you as we're talking. This is a Supreme Court case from 1988, Shapiro versus the Kentucky Bar Association, which was a sort of fundamental case. It has to do with First Amendment rights, commercial rights, but it had to do ultimately with the capacity for lawyers to advertise. That's a secondary issue. What this particular piece is about demonstrates a couple of things. And really many of the things that I had worked on for almost 4 to 5 years, it was really sort of a delight to finally discover this, in some way obscure reference from the Supreme Court. So what they're attempting to do here is to say, hey, what's going on? What are lawyers? And so here, this is, this is a very fascinating piece, and it just basically says, it is worth recalling why lawyers are regulated at all. And in every place here where the word lawyers is used, just substitute architect or design professional. It is worth recalling why design professionals are regulated at all, or to a greater degree than most other occupations. And clearly lawyers are regulated at a much greater degree than other occupations. And why history is littered with failed attempts to extinguish lawyers as a special class. In fact, that's what's happened, is that instead of the problem of distinguishing lawyers as a special class, architecture and engineering has made the claim that they were never a special class at all, and that's why they run by contract documents. Very peculiar. So I'll skip this little reference here, but operating a legal system that is both reasonably efficient and tolerably fair, and we want that in society, we want a legal system that's reasonably efficient and tolerably fair, cannot be accomplished, at least under modern social conditions, without a trained and specialized body of experts. And that is the claim of the licensed learned professional. They are a specialized body of experts. This training is one element of what we mean when we refer to the law as a learned profession. And this is also true in medicine, in accounting, and clearly in architecture and engineering. The training is, unlike a hair braider who has an occupational license, the requirements to join the learned profession are quite significant, and now even to the point of requiring advanced degrees. Such knowledge by its nature cannot be made generally available. Very important. And it therefore confers the power and temptation to manipulate the system of justice for one's own ends. Such manipulation can occur in at least two obvious ways. For those who may be attorneys or have dealt with attorneys, the first one is sort of obvious. One results from overly zealous representation of the client's interests. Abuse of the discovery process is one example whose causes and effects, if not its cure, is apparent. The second, and for the present purposes and for our purposes, much more relevant, problem is the abuse of the client for the lawyer's benefit. Precisely because lawyers must be provided with expertise that is both esoteric and extremely powerful, it would be unrealistic to demand the client bargain for their services in the same arm's length manner that may be appropriate when buying an automobile or choosing a dry cleaner. Like physicians, lawyers, and in this case, licensed design professionals are subjected to a heightened ethical demands on their conduct toward those they serve. These demands are needed. This is very important, this last sentence. These demands are needed because market forces and the ordinary legal prohibitions against force and fraud are simply insufficient to protect the consumers of their necessary services, and they become necessary services because they're given the state monopoly. Consumers must go to these folks for their necessary services from the peculiar power of the specialized knowledge that these professionals possess. You're protecting the decision-making integrity of the agent, and you realize that the agent has opportunistic possibilities which can never be discovered by the principal. And that's a result of the knowledge and the specificity of the information that they possess about the relationship, about the principal. Okay, so I'm going to skip by these because they sort of build to a final one here. The current mechanism by which the discussion has proceeded about a fiduciary duty attaching to engineers or to architects or to a licensed design professional is that courts use a contract-based approach to fill the gaps in the contract post facto, a quasi-contract theory relying on facts specific to each case to impute a fiduciary duty. This doesn't help because you have to do it post facto in any case. Right? And then there's some confusion, as I indicated to you earlier, between tort and fiduciary duty, and this has to do with the constitutive nature of the fiduciary duty and being entrapped in a standard of care argument. We can't go into the inner details of that at the moment, but so I give you the Mickey Mouse version or the Sesame Street version of my talk reduced to a single chart. Note that one thing is not like the others. Right, in the far right-hand corner. Client dollars or many other things at great risk. You know, if you take your daughter in because she has cancer, there's a lot of risk there. If you go in and you have your whatever exam and you've got a certain kind of physical ailment, or you've been, sued by the state or sued by somebody else, a lot of, not only dollars, but a lot of risk. You have a state-granted monopoly. Well, yes, physician, the attorney, the accountant, the architect all have a state-granted monopoly. Is a license required? Yes. Is there significant information asymmetry? Yes. And do they have a fiduciary duty? Well, the architect says no in the right-hand corner there, and it should be yes.
Okay, Ujjval, we have a couple of comments, one from Tommy Smith, and he's suggesting AIA does not consider architect an agent, but a representative of the owner.
Well, yeah, but, okay. Well, that's nice for the AIA to say that. But that's not how a licensed learned professional works. And one of the difficulties is that the AIA has for a long time been confused about this. And it's not surprising that they have been, confused about this. And as one of the implications, as we'll talk about later, is that, in fact, there's no longer any need for standardized contracts of the length that the AIA or anybody else produces. And as you well know, when you go to the doctor or you go to an attorney, and I do this in a room full of attorneys, 50 construction attorneys in the room, and I ask them, have they ever had an engagement that required 80 pages of documents? And the answer is always no. That's because if you're an attorney or a physician, you do not have to have that set of contracts. You can do all of what's necessary in 3 to 5 pages. And it's because you have an affirmative duty. You are not a representative. If you want to be a representative, then you are a vendor. Just like the person who's managing money, who's a broker versus an advisor. And that's going to be a very interesting distinction as we move forward. It's completely plausible for there to be many current architects who decide that they will no longer be licensed because they don't want to be an advisor. They don't want to be an agent. They just want to be a vendor. And that's fine. But then there's no longer any reason for them to be licensed. All right, so let me just cover a couple of quick things. I know there's a lot of things that I say, set off alarm bells, and I'm purposely not looking at all the questions that must be pouring in, saying, well, what is wrong with this person? But in any case, so all I want to suggest here in this slide is that you have contract duties, you have tort duties, a totally separate set of duties, which are fiduciary duties. You have a duty of loyalty, a duty of care. And ample case law already exists to understand how liability can be assigned for failure to fulfill any or all of these duties in the fiduciary care section. So this is not new at all. In fact, because I was a defense attorney for a long time, I haven't spent a lot of time reaching out to plaintiffs' attorneys about this. But plaintiffs' attorneys are going to get this. And in fact, all defense attorney or plaintiff attorneys in construction law often end up having to do both. So the mechanism by which you aver, and you put forward the allegation, and when fiduciary duty will apply is relatively straightforwardly done. And we're going to talk a little about how many of the current practices in design for design professionals fails the fiduciary duty already, and therefore they should be beginning very quickly to manage their risk. Lots of changes are going to have to take place, and we're looking for the proper test case, and there's another number of things. Owners are going to begin to get involved in this very quickly. So let me just try to get to a couple more things, because we want to try to not go too far beyond our time here.
We have a number of questions, and some of them are getting to be pretty lengthy, but I will try to get those in. We need to try to do that probably sometime soon, but go ahead with a couple more things, and then we'll backtrack.
Yeah, and I will say that there's lots of insurance implications. We talked explicitly to senior claims managers in various large A&E entities, as well as brokerage entities. We've done the analysis of this particular area. There's a whole series of things that will follow from this. Obviously, the most important thing, and I'll get to that in a moment, but I'll jump in here just because we don't have a lot of time, is that you can no longer have limitation of liability clauses. When you have a fiduciary duty, it is against not only policy, but against the fundamental nature of a fiduciary duty for you to be able to contract out or to escape that duty. And as such, no limitation of liability clauses can be enforceable. Now, this obviously means a lot of underwriters have to sit and scratch their heads and rethink. We've talked to some of those people already, and we've had some very interesting conversations with them. It is clear that depending on the definition of professional services that is in that document, that insurance contract, that will have a great deal to say about how the underwriting and how the management of this will take place. Remember that a licensed professional cannot contract out of a fiduciary duty. You can't go to an attorney who says, look, that's all well and good, Joe, but for our relationship, I don't have a fiduciary duty with you because I know you have certain types of IP that I might like to rip off. Right. We'll skip this, and we will. One of the most important things, of course, is that fiduciary duty damages are very, very different than the current set of damages that are allowed, and therefore create certain implications for insurance coverage of those damages. I'm going to throw this in here. This is very important in terms of what's going to take place. You cannot act as an advocate for personal biases. Therefore, the green advocacy, which is very, very common in the design profession, has to pretty much stop forthwith. Now, you may get lucky and your client may want to do that, but you have to provide objective information. It's not your job to act as an advocate. It's not the job of the physician or the lawyer or the accountant to act as an advocate for his preferences. And then here, limitation of liability clauses. Now, and I want to get you to participate here, David, and I think it's been very challenging for David as well, as it has for a number of other folks who have been privy to some of the work that I've been doing for the last few years. But in my mind, because of my knowledge of, certainly maybe not to the degree that some of the other people who are, do this on a day-to-day basis for specifications, but specifications are a very, very good example of the current systemic fiduciary failures by design professionals. The cavalier attitude about specifications, the hiding of the use of design fee that eats away at providing the correct specifications and the time for correct specifications, and ultimately the, shall we say, the low esteem in which specifications are held in the profession indicates that very often the owner is kept in the dark about the quality of the risk and the cost and the schedule problems that take place when the design professional does not fulfill his fiduciary duty fully to the owner. So I think David has some examples. Maybe you just want to go through them quickly here because we've got probably another 3 or 4 minutes.
Right, and then we'll double back and take some of these questions that are now piling up.
Yep, I can imagine.
One of the things that I'm faced with often is, as we go through trying to develop the specifications, we have many questions that we ask. We typically embed our questions into the specifications so that they're not forgotten, so that they can be interpreted or read or reviewed in context, and hopefully that allows for a better decision. But what happens ultimately as we draft the specification, the questions are there. The architect, we will deliver the draft spec, and one of the very first comments that we get back from the architect is asking us to remove all the questions. even though it's the first draft of the spec, everyone knows the thing is not done, that it's a first pass. But the architect, for some reason, and my supposition is that they do not want to be made to look in front of the owner as though that they are not able or do not have the information enough to be able to answer the question. So they're trying to produce a set of documents that actually looks finished, giving the appearance that everything is right. But as soon as we remove these questions from the specification, they're forgotten, and they may never be answered. So the owner does not see this kind of activity going on and doesn't understand that the specifications may or may not be complete, and doesn't even understand where the questions are in the specification. And the owner may actually have an opinion that may actually help resolve some of the questions, but they're never given that opportunity, or not given the information enough to be able to make the decision or help make the decision.
And the courts have been very good about this in terms of all of the other learned professions. You don't have to ask permission for the tiniest thing, but you have to ask permission and provide objective information, if you're the agent, from the principal for things that would have a material impact on the risk or the cost or other primary issues that you want to protect the decision-making integrity of the principal for. And this will depend on the learned profession. Medicine has worked out its own set of what is material and what is not material. Law has its own set. Design professionals will have their own set. Accountants have their own set. And that's because each of them deals in a peculiar contextual environment where judgments and eliminating the decision-making integrity of the principal present themselves in different ways. Go ahead, David.
Yeah, and I would ask any of the independent specifiers, sometimes even the in-house specifiers, are you kept aware of what's going on during the course of the project? We include in our proposal that we want to receive design meeting minutes. I usually have to beg for the meeting minutes. We usually do not get them. And recently, I actually had an architect tell me that they try not to publish meeting minutes when I asked for them. So I sat through an owner-architect meeting. It was the first time I had been in the room with this particular owner, and only the second time I had been in this room with the architect. The meeting started with the owner reaming the architect, asking, where is the agenda? Where are the published meeting minutes? Why are we talking about the same things that have been discussed before? And the architect, after the meeting, as I was getting ready to leave, took me aside and was saying to me, now you see how this project is working, and this was a good meeting. So if the owner is kept in the dark by, in this case, obviously kept in the dark, and I am not getting information about the project as it's progressing, I don't know how I can accurately record what's required for the project. We have a similar situation going on now, as we have a month to finish. The project has been on hold for a year, and the architect is just now getting around to looking at draft specifications that we had issued over a year ago. And at this point, we've essentially gone back to the beginning, throw everything away, and start over. So the owner has no basis for making comparisons going forward. And the owner, from the specification standpoint, is not even involved. They're only involved in reviewing drawings. It's a big risk.
Yeah, I mean, look, this is going to have very, very significant implications in the way in which the practice of the design profession is engaged in. And one of those is it has to be affirmative. You can lie by omission and by commission. And the attempts to hide things from the owner, which would be important or useful, such as, hey, wait a minute, we love putting green roofs on everything we do, and then we use crappy studies about the return on investment that we don't even know how to tell whether they make objective sense or not. But let's put that in front of the owner and convince them that they should pay 10 times more for a roof that's green instead of a regular roof. That can't be done. I don't care how much you believe deeply in the beauty of a green roof and how much this is going to save the planet. That simply can't be done. You're substituting your preferences for the principles. And the principal cannot make a decision as to what to prefer unless you, which is the agent, whose primary job is to provide objective information and risk. And if you do not know what is objective information, you cannot pretend to know it. You cannot pretend to use crappy studies because they were published in Dodge Analytics to convince an owner to spend their money. Okay, I'm being mean about this because I see this all the time, right? And this is what we're talking about here. We know that the design fee is burned in a manner which has little to do with the delivering of one of the fundamental contractual documents, which is the specification. And this is done intentionally. Because it's done intentionally, I mean, talk about, it's failing in your fiduciary duty. Your job is not to be a member of a cultural elite. Your job is to provide. This was true in medicine as well. Medicine thought of itself as a member of the cultural elite. They were not measured by if they actually knew what they were talking about. Freudianism is the perfect analogy to the way in which much of what passes for, especially in architecture, professional value. That ended in medicine as well. This is why there are no longer any Freudian psychiatrists that have MDs. At some point, you recognize that this is not actually using judgment. It's simply making assertions. Okay, so see if I can get to your last example.
Yeah. What we end up seeing too on the drawings, and this again coming from a specifier's standpoint, there's often information on the drawings that is either incorrect, incomplete, or simply copied from another project. Especially with today's electronic drawing, whether it's BIM or whether it's CAD, it doesn't really matter. It's all too easy to copy something from a past project, put it onto the drawings, and when it happens, the drawing, the detail, whatever the information is, looks to be complete, looks to be finished. If it were hand-drawn as we were doing years ago, we would know when it's not complete because it would be obvious. But today you don't. So when we're reviewing drawings and we see things, assuming that it is complete, we then later discover what happens is the architect or the designer is using placeholders. And we find out, too, that the placeholders extend to a point where the object, whatever it might be, is something that the architect will consider sufficient to be able to cover the cost of what will eventually be designed, but is not necessarily representative of what the architect truly wants. So at that point, we end up in a VE exercise where we're now arguing about costs placed on an object that happens to be a placeholder. So we have bogus information, and the estimator is using that bogus information, creating an estimate that everybody believes to be accurate, but it doesn't really represent the design at all, or what the intended design is. So it creates this enormous risk for the owner, because now we're trying to sort out what the real cost of the project is. When we finally decide, we still may be over budget, and there was no way to know. Okay. So, Ujjval, if you don't mind, we need to attack some of these questions.
Go for it. And before you do that, I encourage people, if they don't get a chance and have their questions answered, we're going to give my contact info and certainly David's. But for those of you who feel particularly in need, I'm happy to talk further. And would welcome that conversation. So go right ahead, David.
Okay, so the first one up from Kevin O'Byrne. I'm going back quite a ways here. The session is being presented as a set of absolute statements. One court decision does not mean that there is a new paradigm. It appears the jury is still out on this until there is more case law establishing the position that the presenter appears to be putting forth as some type of established fact.
Okay. I get this all the time as well, which is, wait a minute, X courts and X case law hasn't ruled this way. Well, case law has ruled this way in virtually all of the learned professions already. There's vast case law on this. That's why I gave you this one Supreme Court case. This is not an unusual structure, and I mentioned from the beginning, this is from first principles. And when you understand that all of the other, that's why I set up that sort of, Mickey Mouse chart. When everybody else has to do this and you don't, then the question I would respond is, show me why you're different. Because if you're not different, and we're talking about it in a categorical way, right, then you have to have a fiduciary duty. Are you a licensed learned professional? If you tell me you're not, I'm safe. You can say, fine. I can go around and have contracts and be an arm's length vendor. It's not that hard. I mean, plenty of attorneys who have vast experience, I can explain it in, half an hour, 45 minutes, and they get it. Senior claims managers at big A&E places go, I've never thought about it this way, but it makes perfect common sense.
Okay.
But the least what one would want to consider is, if you're doing risk management, and there's even a 20% chance you may think, or 10% chance that you think that what I've presented is coherent from first principles, the way to manage your risk is to very quickly say, what the hell could this mean, and would I have to wrestle with this?
Okay, I have a comment here from someone that you know, Ujjval. We have Fred Butters, who happens to be an architect and an attorney. He's writing, while the AIA documents do not expressly acknowledge the fact that the architect is an agent of the owner, the architect fits that legal definition. As a legal proposition, an agent is a person authorized to act on behalf of another. The architect is authorized to act on behalf of the owner, and the law will consider the architect an agent even if the architect accepts this status.
Yeah, and that's why I responded the way I did, and thanks, Fred, for that comment, as it were. And those of you who don't know, Fred sat on the AIA Risk Management Committee for many, many years and chaired it for quite a long time, and was the person who had primary conversations with virtually all of the major A&E players in the country. Yeah, I mean, you can say you're a representative, you can say whatever you want to say to, assuage your position, but courts will see through that, and if you look at the first principles, it's pretty easy to see through that as well. If you have a self-interest in the way in which it's all currently constructed, I can understand this is going to be a high bar to jump. Lots of people have led their lives in a particular way, just as many physicians led their lives in a particular way in the 1950s, 60s, and 70s, who rejected the notion that they had a fiduciary duty. They believed that they knew better than their patients. They were better educated. They were more cultured. Name whatever you want to name. They simply knew more than their hick patients. Why should they listen to them? The fact that this sounds kind of silly now is what you need to be able to think about, right? That you are acting as an agent. The fact that people argue about that is sort of puzzling to me, because that's what you dream of doing as an architect or an engineer. It's your job to use your knowledge to help the owner. That's the only reason he hires you for your services. Go ahead, David.
Okay, we have so many, it's hard to choose from. Okay, so here's one from Brian Klein. Quite often, lawyers and accountants will be paid by the hour in order to offer fiduciary advice. How would being a fiduciary affect client billing, especially in regards to government work, since federal and local governments will award project to the design team that offers the lowest cost?
So the first thing to remember is that the billing practices of lawyers or physicians doesn't have to do with their fiduciary duty. They have a fiduciary duty no matter how they bill, right? And that means that you have to figure out within the profession how billing is going to be done. Maybe it'll be done differently, maybe it won't. This is going to have some very difficult circumstances. What will happen is that many of the people who currently claim to be licensed design professionals will reject it and fall out of the profession. And those who have high degrees of competency and the capacity to manage their risk to practice will be able to charge a premium for what they deliver. This is going to have vast economic impacts, and it's hard to imagine what that answer is. I wouldn't want to prognosticate as to what that billing structure is. I'll only say one thing. Most government projects, well, all government projects have to have bonds on them for a very specific reason. What is going to take place is most sophisticated private owners and virtually all government owners very quickly will realize that they will have to demand a fiduciary duty of every design professional that they use, because the key thing that is being done there is protecting the taxpayer money. So the best way to protect the taxpayer's money is to make sure that the designer has a fiduciary duty to the owner, so that we don't have 50, 60, 80, 100% overruns in costs just because a particular designer wants to do a fancy building for the government. I mean, it's going to be an easy proposition, because the minute one large institutional owner says, I want a fiduciary duty, otherwise you can't have this job, people will figure out how to deliver that. And we haven't talked about that at all here, but this is why design builders will very quickly come to understand that they will offer a fiduciary duty by contract, because the design builder will become like the hospital who will be employing the doctors. And even though the doctors have a fiduciary duty to the patient, they have an employer-employee relationship with the hospital. And as such, design builders will simply say to major sophisticated owners, we're going to give you a fiduciary duty, and we're going to protect your interests first. And that will be one of the most powerful and productive ways in which to extract risk from the construction industry and increase the overall efficiency of the industry, including eliminating gray market activity within the construction process.
Okay, I think I need to finish with one last one. We're right up against 4 o'clock. This is from Ashley Coco. It says, owners are not kept in the dark. They hire professionals for their expertise the owners do not possess, or the level of detail the owner does not wish to deal with. So he's asking, Ujjval, are you debating the entire profession on this topic?
Well, there's two things. One is, I don't know very much about cardiology. Therefore, I hire a cardiologist. Or I don't know very much about building my country house, so I hire an architect. I hire the architect as an extension of me, right? There are a lot of minor decisions that I'm willing to allow that architect to make, but remember, the key decisions which are to protect my decision-making integrity still reside with me. I do not give those away. And as you remember, I made the distinction, to go back to the very first slide, which is that there's a difference between a principal / client / owner and a patron. The profession cannot be based on patronage. The profession has to be based on delivering objective, valuable services to a principal or a client who does not possess that knowledge by definition. Otherwise, much of the economics of society would break down. This is why the Supreme Court case talks about having a body of experts. When you have a body of experts, that doesn't mean I go to the doctor and say, hey, I don't know anything about this, you make the decisions. So yes, I am questioning very fundamentally the process by which this is thought out. And I would argue very, very strongly, we don't have the time here, that both in terms of the fundamental economics and the fundamental value proposition of a licensed design professional, having a fiduciary duty begins the task of, from first principles, clarifying and really allowing them to join the ranks of 21st century professionals.
Okay, and with that, we're past the hour, so I think we really do have to cut this off. We really appreciate all the questions. We appreciate your attention. We know it's a controversial subject, and everyone is going to have their own opinions for certainly until we start to see some of these cases tried before the courts. And then it may very well shape the industry just as it has for other licensed learned professionals. So with that, Ujjval, I'd like to thank you for joining me today. I really appreciate you being here and shedding some light on this subject.
And thanks very much, David and Matt. I really appreciate the opportunity. And I encourage people to, and in fact, let me go to that. I'm going to put up as the last slide, there you go. This is my contact information. And David's contact information. All arrows and barbs should be directed at me and not at David. And so I look forward to talking more with some of the people who might have attended this webinar. Thanks.